something that would require protection under the law. And so to put this into perspective, it would be information relating, for example, to your family, to your children, your marital status, your sexual orientation, etc. I'm going to yield the floor to Gentrix.
Thank you, Kaga. I think that was really clear. We'll now look at the legal and regulatory framework of data protection in Kenya. I've seen a really interesting question in the chat about whether, let me just read it out loud, whether we are solely guided by our local data protection laws or expected to take into account other regulations like the GDPR, which is often regarded as universal. This is a point where we'll answer that. In this section, we'll be answering that question. That's a really important question. So in Kenya, we have a set legal and regulatory framework. Of course, the most important law in the land is the Constitution. And as we said at the beginning, privacy is so important that it's recognized as a constitutional right under Article 31. And that's where acts like the Data Protection Act gets their provisions from or gets their mandates from. So we have the Data Protection Act, and the Data Protection Act also comes with a couple of regulations, such as the general regulations and the complaints handling regulations. Lastly, and very, very importantly, we also have sector-specific laws. What do I mean by sector-specific laws? Right here, you're all PMs, but I'm sure that you all work in different companies. There are people who work in edtech, there are people who work in fintech, there are people who work for just general companies, there are people who work in health tech. You know, the list is endless. And so depending on which sector you fall in, you'll find that a lot of them also have their own privacy mandates or regulations. So for example, when people who work with edtech or anything to do with children, then you also need to be aware of the Children's Act, which has specific laws or regulations that govern children. Or if you are in fintech, then there are acts like the Central Bank of Kenya Act or the CMA Act and a host of regulations that also cover you. And I think anyone working in tech, you also need to be aware of the Kenya Information and Communications Act, which covers most of the communications, especially digital communications. Going into the DPA, and again, Ivy, we're moving on more into your question, the scope of the DPA. So the Act, as you've said, it applies to processing of personal data, but which personal data? So we spoke about the either automated or non-automated means. So it doesn't matter whether you're dealing with a digital platform or a more physical one, you still need to be aware of the data protection laws. And then the other thing we talk is about the jurisdiction. So in Kenya, we have, under the Act, we have territorial jurisdiction and subject matter jurisdiction. What does this mean? For people who work in companies that are registered, so I'm using companies, but this can also be, you know, your SMEs, your SACCO, whatever it is, your entity, an entity that is established or ordinarily resident in Kenya. And then you are also processing personal data while in Kenya. Then the Data Protection Act will apply to you. So think about, sorry, I've seen a question, I'll come back to that. Think about, you know, any company registered in Kenya dealing with data, your Safaricom, your Airtel, I don't know, I'm just thinking of the telcos, but any company registered in Kenya. And then the other one is where this entity is not established or ordinarily resident in Kenya, but you are processing personal data of data subjects located in Kenya. And I know that for techies nowadays, the dream is to have a remote job, right? But where you have a remote job and that company is dealing with Kenyans, even if they're not Kenyans, but they're processing the personal data of data subjects who are located in Kenya specifically. Located, the keyword here is located in Kenya. Then you will also need to know the provisions of the Data Protection Act. We have the GDPR, and other such data laws. What is important here is for you to know, I would say, around 3 things. What is your company or entity or employer? Where is it established? Secondly, and thirdly, which data subjects is it dealing with? Because I don't know how many are aware of, for example, with Truecaller. Truecaller is not a Kenyan company. I'm forgetting which country it's from. If someone can type for me in the chat, or Kega, you can remind me. So it's not in Kenya. I don't even think they have offices here. Oh, it's Swedish. But perfect. It's Swedish, but it processes Kenyan data, because if you go to Truecaller, someone has called you and conned you, and then you type the number, it will most likely be there. So they process Kenyan data, but it's not established in Kenya. And if you a few weeks ago or months ago, they had a case in Kenya, and they were fined for not being registered as data controllers. So you need to just be aware of the 3 things that we said. Where is your company established? Is it Kenya? Is it not in Kenya? If it's in Kenya, automatically, if it's in Kenya and it's processing personal data, automatically you have to, you fall under the Kenyan purview. If it's not in Kenya, but it's processing data, that belongs to data subjects who are resident in Kenya, then it falls under the purview. You'll find that many international laws follow the same kind of thinking. So with the GDPR, again, ask yourself, what company am I working for? Am I working for a European country? If yes, then obviously the GDPR affects you. Even if you're not working for a European company, but you are handling data by European residents or citizens, then you'll fall under the purview. So that's why it's not a yes or no question. It just truly depends on which entity you belong to and what it's doing. I hope that's clear. Okay, that's great. We will move on. Over to you, Kega, to take us through the data protection principles.
Perfect. Oof. Can you be able to see the next slide? I'm trying to change it.
No, it seems I think maybe your laptop is hanging. You can continue as I share mine.
Perfect. So now I'm going to be canvassing the data protection principles, and essentially we have several, which can be summarized in a few words. So we have the principle of accuracy. Here it entails essentially having information that is current, and it also has some certain qualifications. The first of which is prompt deletion of wrong information upon notification by your data subjects. And the last is the right to rectification. And so one of the rights that you're going to be talking about later that data subjects have are the right to rectification, as well as the right to deletion. Thank you, Gentrix. As well as the right to deletion. At the same time, we also have the principle of lawfulness, fairness, and transparency. And this essentially implies that you need to have a legal basis for collecting any information. Secondly, is that the information that you're collecting needs to be fair. There needs to be a level of proportionality in terms of the information that you're collecting. Often I find that with some of my clients is that they go out of their way to collect a lot of unnecessary information that is not going to be useful to them. And so also the aspect of proportionality is important in terms of how you're dealing with information. There's also the aspect of transparency. And so this refers to the fact that you need to be very clear to your data subjects about a couple of things. It could include details like who you're going to be sharing the information with, how long you're going to be keeping that information, and who is going to be having access to this information. The other aspect is on purpose limitation. And this essentially infers or implies three things, which is specificity, that the information also needs to be explicit and legitimate. And so what you mean by this is that, for example, if your company is limited towards providing fintech solutions, then collecting information about, for example, a thing that would not be essential in that process would be unnecessary. And so in my estimation, it would be, for a financial transaction, it would be say like details of, I don't know, depending on the industry that you're in, some information could be superfluous. The other thing is on cross-border limitation. And so one of the things that Gentrix mentioned is that there's an aspect to how these laws are going to apply. So generally, the Kenyan Data Protection Act is going to apply on account of the subject matter, as well as the fact that you're a foreign entity that is processing information that relates to Kenyans that are in Kenya. The other interesting bit is that other laws have another unique character. For example, the European GDPR, as Gentrix had mentioned, where we find that the GDPR is going to apply to entities that are going to be processing this information, regardless of whether they're located in Europe or not, provided they are processing any information that relates to any European citizen. It doesn't matter whether they are in Europe or not, provided it relates to a European citizen, then it's going to apply. The reason why this is important is on account of the nature of some of the operations that you have as product managers. You'll find that often there are providers that you are relying on that do not belong in Kenya, or that have servers that are not located in Kenya. And so in some of those instances, you might need to have an information sharing agreement that is going to ensure that the information that you're sharing is adequately protected. The last thing I'd want to mention is on storage limitation. Often we find some of our data controllers and processors that we're dealing with have a desire to keep information for a period longer than is required. And so my suggestion would be, it's important to understand some of the sector-specific limitations that could be there. For example, a person in health knows the storage limitations that apply, and a person in finance equally knows what their requirements would be. So here I'd ask for discretion on your part to be able to understand what would apply to you. We can proceed. And so here is one of the most important things that I would want all of you to leave this webinar with, which are the rights of the data subjects. So essentially, these are the rights that all of you should have under your fingertips, because they're going to define the dynamics of your internal operations, both in terms of looking at the operations generally, as well as looking at issues that apply from a departmental perspective or from a case-to-case perspective. So a data subject has a right to be informed of the use of their data. So what this means is that you need to be very specific with your data subject about the information that you're going to be collected, as well as how the information is going to be used. Secondly, a data subject also has the right to access their personal information that you as a data controller or processor have in your custody. And you as a data controller or processor have an obligation of fulfilling this request within 7 days. And this personal data is meant to be given in a file readable format to mean that it's in an easily available form. The other thing is that a data subject also has the opportunity to object to the processing of the information. And so we're going to be talking about consent later, but essentially what that implies is that a data subject has a right to withdraw their consent, and they also have the right to alter what their wishes would be depending on where you lie on the data protection cycle. They also have a right to correction of false or misleading information, and this correction needs to be done within 14 days. At the same time, there's also an obligation to delete false or misleading data, and there's also rights relating to data portability. Data portability is what we often see when we use our emails or our social logins to be able to access other websites or services. For example, it's possible for you to access your Facebook account simply using your Google details. All you need to do is just accept, and Google is going to transfer the information that they have on their records to Facebook for them to use it for whatever purpose you have given them permission to do. Lastly, this right can be exercised by three different people. It can be exercised by the individual themselves, or it can also be exercised by that individual's parent, guardian, or appointed administrator. And it can also be done by a guardian or an administrator in an instance where the person has a mental incapacity or a disability that prevents them from giving consent. So a good example of this, for example, is when a patient is being onboarded at a hospital or a health institution and the person is incapacitated, or an instance where a person has a mental incapacity and might not have the capacity to exercise some of these rights. Now I'm going to take some of the questions that have been raised on the comments. How long is long enough when it comes to data storage? As I mentioned, often you'll find that there are sector-specific considerations that you need to have in place. For example, for people in finance and even for tax records that are required, we often find that the retention period is about 7 years. I believe for medical records, the period could be shorter. And so depending on the nature of your operations, you can be able to determine internally how long you should be able to retain some of the information that you have. At the same time, there are also some considerations depending on the sector that you're in that are going to dictate how long, how, and who can be able to have access to certain criteria or categories of information. The other question is from Isaac Opio. Most local banks have hired services of core banking offered by foreign-based companies with servers out of the country. How do they comply? They comply through having information sharing agreements, or where there's an adequacy decision that has been offered by the Office of the Data Protection Commissioner. So an adequacy decision is essentially a determination by the ODPC where they deem a particular jurisdiction or territory to have adequate laws or policies that would be able to protect data or information. And so one of the things that you can be able to do once you get into such arrangements is that you also meant to provide essentially the criteria that you use to determine that the information that you're going to be sharing is going to be safe, and that the same safeguards that you've been able to put as a data controller or processor here in Kenya are the commensurate protections that are going to be given to the data when it's transferred to these third parties that you're going to be sharing this information with. I hope that makes sense. We may proceed. The next section is on collection of personal data. And so personal data has a few considerations that I believe we should all understand. So generally is that data must be collected directly from the data subject, and that the purpose should be lawful, specific, and explicitly defined. Of course, there are going to be exceptions that are going to apply. Some of these exceptions include that personal data may be collected indirectly, where the data is in a public record, or where the information has been deliberately been made public. The other consideration is consent. Consent is going to be one of the main reasons that you're going to be relying on to process your users' data or your data subjects' data. The other exception is collection for another source where it's not prejudicial. And so, for example, you can find information that is readily available, for example, from books, from publications, and therefore you can be able to use that information if it's not prejudicial. And then the last thing is necessity, where there is a legal reason for that to happen. And then lastly, there's a duty to notify. So before you collect data, the data subject must be notified of the rights where their personal data is being collected. So data processing is what I'd made reference to before, and it's essentially personal data may only be processed with the consent of the data subject or where the processing is necessary for the following purposes. So generally it's compliance with a legal obligation. So if you're in the fintech industry, there's some certain KYC, AML, CFT obligations that you might have. And so in that respect, that would be processing in relation to a legal obligation. Secondly, it would be in the protection of the vital interests of the data subject. So this would be in furtherance of things like provision of health services, or when it's something that could be reasonably expected. The other reason would be for a public interest reason, or for a public purpose, for example, official authority that has been vested in the controller. The other lawful purpose is the performance of any task that is carried out in a public authority. The other is contractual performance. And so where you've entered into contracts with the users or your data subjects, there are some certain scenarios that are going to require you to collect and process information. And so that's also going to be a valid reason. And lastly, it's for the purpose of historical, statistical, journalistic, literature, art, and for scientific purposes.
Thank you, Kega. I would like to move into consent, if we're all on the same page. So for those of us who are interacting with Kega and myself for the first time, whenever we do a training, we try and make it as interactive as possible, because yes, it's very theoretical, but when you are making your decisions on the go, you're designing a new feature, pushing out a new product, you'll need to have these things at your fingertips. So don't worry when you're asking are we on the same page? Are we on the same page? You just want to make sure that this is actually useful to you in your day-to-day. So am I getting some thumbs ups, or should we clarify something before we continue? Okay, great. So as Kega has said, consent is one of the most important things whenever you're talking about data protection, data processing. So as we said, you cannot and should not process data unless the particular data subject consents to the specific purposes. So sometimes you might get consent, right? For example, if think about a child and then the child asks, Mom, can I go to a party this weekend, right? And then mom says, or if you're lucky, the mom will say yes. If you're not, they'll say whose party, right? And that's kind of the same here. Whenever you are asking for consent, the law requires you to be specific as to what you're asking for consent for. So it's not just enough to have your small, sometimes, a lot of people just, download your small data protection policy online and then you put it on your platform. That is, it's well and good, it might work. But what's more important is for you to make sure that whatever consent you're gathering is specific to your purposes. Because someone might, a user might consent, let's say I consent, the policy says they consent to have their name shared, for example. But then the feature or the products that you have, it displays both their name and say phone number, for example. Are you seeing the difference? So whenever you're gathering consent, you have to make sure that the data subject consents to the specified purpose or purposes if there are more. So it's an offense to fail to obtain prior consent. And when we're talking about consent, there are some clarifications that it has to meet. It needs to be express, it needs to be equivocal, it needs to be free, specific, and informed. And I think we'll look at this a little bit more moving on, but just to show you how detailed your agreements or policies need to be, so that if a user, most people don't actually read those things, but if a user were to read, would they understand what you're going to do with their data? And if they understood, would they then give their free and equivocal and specified consent? There should also be a clear affirmative act signifying agreement to the processing of their personal data. So for example, let's talk about the cookie policies, for example. The buttons that are there, you click allow only necessary, or deny, for example. Those are the clear affirmative actions. Remember that because this is an offense, then the burden of proof to demonstrate that consent will fall on the controller or processor. I think that's an important obligation to know. And then if there is any further processing, it also needs to be in accordance with the purpose of collection. So for example, you collected the data for allowing the user to access a particular platform, for example, and then you need to process it further. So I need to use this name, not only to allow you to access the platform, but to allow you, say, to be able to share the platform, for example. So any other processing, it needs to be in line with what you collected it for. Not that you get my consent, I tell you, okay, you can take my data and use it to enable me to access the platform, but then you use it for something else. And we'll talk about some of those other purposes that people use it for, and later on land into a lot of trouble. The final thing to learn about consent is that it can be withdrawn at any time. However, this will not affect the processing of data that was done before the consent was withdrawn. So there's also a balance. It's not just up to the data subject, but once the data subject withdraws their consent, then anything that happened before they already gave you. And this is really important for, I think, when you're thinking, again, because you're thinking as product managers, you're designing or overseeing a product or a feature. I gave you consent to, let's say, for example, publish my name, and then I remove it. Will you then be in trouble because there's a post of mine from 2017? That's not the case. The removal of consent only applies for actions that will come after the fact. So the users that I was saying are restricted. We have a number of restrictions when it comes to data processing. Around 4 categories. This is when we are talking about children, when we're talking about objections, any objections, commercial use, and automated individual decision making. Because of time, I'll really try and rush through all of them. So data relating to children should not be processed unless there's consent obtained from a parent or guardian. Children, because they're children, you're not able to obtain consent from a child. So if you're processing data that has to do with a child, the consent needs to have expressly come from their parent or guardian. So if you're, again, the EdTech people or anything, games, all of that, if you're dealing with children, that's something that you need to know and need to learn how to work into both your features and into your agreements. The processing should always be done in a manner that protects and advances the rights and best interest of the child. So it's not only enough to get the consent of the parent, but you also need to be mindful of how you are then processing that data. And for children, you have a higher standard than just a normal user. The other one is objection. So if a data subject objects to the processing, the legal basis for processing is immediately lost, unless you as a data controller demonstrate a compelling legitimate interest for that processing that will then override the data subject's interest or for the defense of the claim. Unfortunately, this is a bit, I know it may be a bit vague, but it will really come into play on a case-to-case basis. But where the most important thing to know is that when a data subject objects, you don't have the right to continue processing unless you have a really compelling reason. And if this were to go either to the ODPC or to the court, then it will be up to the arbiter to decide whether your reason for processing was more important than the data subject's interest. The other restriction we have is commercial use, and we'll be covering this a bit later under image rights. But basically, you are forbidden from using the data subject's data for commercial use unless these three criteria are met. So first of all is consent. We've already talked about consent, it's the most important bit. The other one is maybe there's an authorization under a written law, and the data subject has been informed of the use when you're collecting it. I think for, let's say, for example, for advertisers, advertisement is, so if you're working for maybe a PR firm, an advertising firm, or anything like that, advertising is a commercial use. Sorry, advertising is a commercial use, and so you need to be mindful of whether the consent has been given or if there's such an authorization for you to use that data for commercial use. And so when you're using personal data for commercial use, the personal data should be anonymized in a manner that ensures that the data subject is no longer identifiable. And this is the only exception, of course, is have you obtained the consent of the data subject to do anything otherwise. Again, as I said, we'll be covering this a bit more in detail, so I'll just move on. The last restriction we have is with automated individual decision making. This might shock some of us a little bit, but basically, when you talk about the rights of the data subject, they have a right not to be subjected to a decision that is based solely on automated processing, such as profiling, which produces legal effects concerning the data subject. A few years ago, and I'm going to go on a tangent a little bit here, in the UK, there was an uproar. They usually do the end of high school exams, and then there's a system that places them into their universities of choice. And there's a point where they used an automated machine to do those placements. I don't know if anyone, if you came across that story, you can send me a thumbs up or comment. Yeah, but basically these kids, they've really studied hard, and then the decision about which school they are going to was solely based on an automated machine. And this is some of the ati hatujawahi toka Kenya. It was on the news, mimi niliona Twitter. So yeah, that's not actually allowed. They have a right, data subjects have a right against this. And the exceptions, of course, number one, we all know now, the most important thing is consent. Where there's consent, you're able to do that. Another exception is if it is absolutely necessary for the performance of a contract between the data subject and the data controller. And if there is an authorized law to which the data controller is subject, which allows for this automated processing. So those are some of the exceptions, but the rule of thumb to remember, because as product managers, you're mostly dealing with digital platforms. So you need to ask yourself, what are some of the actions that my platform is performing? Is one of those, automated individual decision making? Because you'll find that a lot of platforms actually do that. I will now cover sorry about that. I'll not go through cross-border transfers. I think Kega did a good job at introducing this. Basically, the rule of thumb is that you're dealing with data in Kenya. The law wants you to protect it as much as possible, and as much as possible, keep it here in Kenya. And as it has been alluded several times, you'll find that your service providers are not necessarily Kenyan, or they're not resident in Kenya when you're thinking about cloud storage and all of that. So what can you do? So as a data controller or processor, you have to provide proof to the ODPC on appropriate safeguards on security and protection, which mostly includes jurisdictions which have good data protection laws. The good thing about this is that, we are, unfortunately, we are a third world country. And so we tend to use service providers who are not from third world countries, mostly from the West, your Amazons and what have you. So some of them are already recognized, but this is still a process that you need to do and ensure that if you're transferring data, then it's going to a jurisdiction that has those appropriate safeguards. A transfer can also only be done when consent of the data subject has been obtained. I think we've already covered that one. And the ODPC may suspend processing such information to protect the rights of fundamental freedoms of the data subject. So I think when we're talking about the jurisdiction, the extraterritorial reach, remember we said that the right to privacy is actually a fundamental right. It's not just one of those things that can be taken lightly. So it's so serious that the ODPC can decide to step in where they see that a fundamental right of freedom is being infringed upon. So for the necessity of the transfers, when can we say that a transfer is necessary? There are 6 main grounds. I'll just quickly go through them. The first one is a performance of a contract between the data subject and the data controller, the data controller. The other one is a performance of a contract between the data controller and a third party in the interest of the data subject. And a good example of this is, as we've been saying, the service providers. So maybe your data needs to be stored, and so you enter an agreement with a third party to give you storage capabilities. If it is a matter of public interest, and if it is causing the establishment or exercise of a legal claim, to protect the vital interest of the data subject, and if there is another compelling legitimate interest by the data controller. So processor, I think what you'll notice with all of this is themes of consent, necessity, legitimacy are what really keep on coming up. And so those are some of the concepts that, as we said, just need to be at your fingertips, and you need to consider at all times. I'll now hand over to Kega to do what I believe is what we're here for, the role of the project, the product manager in data protection. Over to you, Kega.
Thank you. Maybe before we proceed, any questions so far? Yes, I'm seeing a few questions from Ivy and Isaiah. I can answer Ivy's and then I can let Gentrix answer Isaiah's question. So Ivy asks, are we solely guided by our local data protection laws? Are we also expected to take into account the EU GDPR regulations, which are often regarded as universal? So I think that's a very interesting question. And typically there are some developments. Thank you. Gentrix tells me that we've been able to cover this question. Do you want to cover the last question?
You can go ahead, though I know that you can go ahead because it's something that you'll cover in the next year.
Okay. So on the role of the product managers in data protection, we have a few things that we need to put into consideration. And these are what I refer to as paradigms. Paradigms to mean frames of thought that you're meant to have as a data controller or as a data processor acting in your capacity as a product manager. So privacy by design implies privacy and data are embedded through the life cycle of the product that you have, from the early design stage through development, use, and ultimate disposal or disposition. And for example, elements of this are encryption, having pseudonyms, and things along that line that can be able to ensure that privacy can be seen in the operational elements of what you're doing. The other aspect is privacy by default. And privacy by default implies that an individual does not need to take any affirmative action for them to be afforded the maximum level of protection. And so you might have seen from websites that by default, it allows a user to accept the highest level of protection, where it removes the marketing and the marketing cookie, as well as a cookie maybe for sharing information with third parties, so that by default, even by the user just clicking, they can be able to get the highest form of protection. Similarly, we have to talk about image rights, because image rights is where the bulk of issues to deal with data protection are going to stem from. And even from a study of all the cases that have been brought forth that relate to data protection, from the High Court, also to the ODPC, we've noticed that most of the complaints are going to come from, one, using images of individuals without consent. That's the most important thing that we've seen so far, that it's the use of an image and that it's connected with a lack of consent. And so generally, image rights are comprised of two things. It has the right to privacy, as well as the right to publicity. And these rights are going to give the individual certain characteristics. That to mean that the individual, but through the right to privacy, has the right to have the information protected. But at the same time, they also have the right to use their personal image for commercial exploitation if they choose to. And so what that means, in the event that the image is used for a commercial purpose, then their right to publicity is going to be invoked. And to be able to determine whether an image right has arisen or that an image right infringement has arisen, there's a case that was decided by the High Court. And the case is Jessica Clarice Wanjiru the details are available on the screen. And it's a 3-part test. The first is that it's a use of a protected attribute. And so this could be an image, it could be a silhouette, it could be a voice, it could be a signature, it could be, for example, something that is fairly unique in terms of artistic expression. Secondly, is that it needs to be commercial. It needs to be commercial. And courts have ruled that it can either be commercial through what could be conceived to be an exchange of value, or it could also be an exchange of a favor or a promise. And so, for example, in the Shimlon Kuria case, where Shimlon sued a university for using his image without consent, the reason why the court was able to deem it as having attained the commercial purpose ingredient is that the university had used his image to be able to solicit for funding. And so they did not necessarily get monetarily exchanged monetarily, but they got it in terms of funding, whether they got it or not. And then the last thing is that the consent was not granted. We can continue. So what can you do as a product manager to promote data protection in your teams? The first thing that you can do is that you can ensure that your company and key stakeholders have undergone data protection training. And so depending on the organization that you work for, there are some certain departments that demand that the employees or their consultants are trained on matters to do with data protection. For example, people who are dealing with sensitive categories of information. And so this could include financial information. It could include health information. It could include information relating to your family, things along that line. And so in that respect, you might need to ensure that people that are within these departments have been trained. And at the same time, there are also sector-specific guidance notes that have been published by the Office of the Data Protection Commissioner that are also effective to provide guidance into specific industries. For example, there's been a guidance note on education, on health, on digital lending services. There's also been one on, there are several. And so depending on whatever industry you're in, it would be wise to confirm whether there is a guidance note in place that also applies to you. Secondly, it's also important to review the material contracts and agreements that you have with any third party or that you have with any provider that is offering you a product or a service. And so in that respect, we've often found that it's important to have some specific clauses that can be able to address data privacy concerns. Thirdly, it's also important to implement policies that are going to ensure both internal compliance as well as external compliance. As Lotus, we view internal compliance as the actions that you're going to undertake as an institution or as a product manager to ensure that your company is complying internally. By internally, we mean, for example, having an internal data protection policy. So this is a policy that is going to define how your staff members are going to be using data, how they're going to be collecting it, how they're going to be storing it, and essentially all elements that are meant to be maintained by your organization. Another important document would be a consent form, where, for example, when you know you're going to be collecting information from individuals, you're going to be using it for commercial purpose, then you know you need the consent form. If you're going to be collecting it from children, you know you need a consent form. At the same time, you're possibly going to need some external facing documents. For example, an information sharing agreement where you're dealing with third parties or with other vendors, or an external data protection policy, which is a policy that your data subjects themselves are meant to be accessing to understand what their obligations and duties are. Lastly, it's also important to ensure that you are taking care of incidences and data breaches that may occur. And so ideally, this is through aspects such as the training that you will have undergone internally. It could take measures such as using the incident management policy, which is essentially a policy that shows the organization exactly what to do when an incident occurs or when a data breach occurs. So those are some of the roles of a product manager in data protection to ensure that you are in compliance. Next, we're going to be canvassing data breaches. And so a personal data breach refers to a breach of security leading to accidental, unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed. The consequences include a penalty notice or administrative fines of up to 5 million shillings or 1% of your annual turnover. And so when you're looking at the ODPC, there are a few roles that they have that I'll be discussing later. But one of the fundamental things that I want you to understand is their role as a regulator and as an enforcer. And so in that respect, they've been given two powers. The first is administering what is referred to as an enforcement notice. And the second is what is referred to as a penalty notice. And as we proceed later, we are going to be seeing what these things mean exactly. And an enforcement notice is essentially an order by the ODPC telling you as a company that you need to comply in A, B, C, D way. And they give you an opportunity to comply. If you don't comply, is when a penalty notice is going to be issued. A penalty notice is essentially a fine that is issued upon a data controller or processor infringing the right to privacy. We can move on to the next slide. And so what do you do in the event of a breach? So the first notification should be done to the data by the data controller to the ODPC should be done within 72 hours within knowledge of the breach. In the event of a delay, the reasons for the delay should be given. And so here I want you to notice a few things that are very, very specific about the statement I've just read. The first is the period, 72 hours. The second is a qualification, is the knowledge of the breach, not when the breach occurred, but the knowledge of the breach. Because often you'll find that a data breach may occur, but the security team or the dev team that you might have is discovering it at a later date. And so here there are two things. There's a period itself, there's a qualification on knowledge and not when it occurred, and then what happens upon delay. I hope you've been able to note those three things. For the data processor, we are referring to the employees, or depending on where you lie on the data protection life cycle, you can either be a data controller or processor. It's a spectrum. And so if you're acting as a data processor, you have a duty to inform the data controller within 48 hours. And so if you are an employee, legally, if you are aware of any data breach or any concern, then you have an obligation of ensuring that you've reported to your data controller or your boss within 48 hours. The data controller has to communicate to the data subject within a reasonable period, unless the identity of the data subject cannot be established. And then there are some details that have to be included, for example, description of the breach, measures to address the breach, as well as mitigation measures and details such as the identity of the perpetrator. Any questions up to that point? If you have, maybe you can send them on the chat so that we can address them as we are concluding. on the data protection officer, so this is an individual or an entity that ought to be appointed by a company or an institution, and their sole role is to ensure compliance with the Data Protection Act, as well as provisions of Article 31, as Gentrix had explained. And so this is an individual who has some adequate knowledge on data protection and can be able to offer a few services. So these services include advising data processing requirements provided under the Act or any other written law. They also have an obligation of cooperating with the ODPC on matters relating data protection. They also advise on data and data protection impact assessments. And so there's something that is fairly important to do when there's a likelihood that the rights of individuals or data subjects are going to be infringed. And this is referred to as a data protection impact assessment. And so this is an exercise that needs to be done when you believe that there's a likelihood that you might infringe on the rights of your data subjects, or that the categories of information that you're dealing with have superseded a certain degree. And so in terms of what the DPO should do is that upon the realization of such an event, then they should be able to ensure that an impact assessment is undertaken. At the same time, an organization also ought to have a data governance committee, and the DPO is going to act as a chairperson, and the members shall stem from the relevant departments from the organization, depending on how your specific organization is organized. And essentially, the role of this governance committee is going to be dealing with any incidents and breaches that occur. They also have an obligation of maintaining data protection policies and culture of good governance. And lastly, they can provide advice to the DPO on matters relating to data privacy. Perfect. So there's a person that we have kept mentioning, which is the Office of the Data Protection Commissioner. As we speak, it is headed by a chairperson. Her name is Emmanuel Kasait. And essentially the powers that the ODPC have are the ones that have been detailed below. So they are a regulator, implying that they oversee implementation of the DPA. They also have an obligation of registering data controllers and data processors. And so, as Gentrix had said, there's an obligation that is going to arise for an entity to register as a data controller and as a data processor. And there are certain elements that are going to determine the tier that you're going to fall under. So there's a small data controller or data processor. There's a medium data controller or data processor, and there's a large data controller or data processor. And so these are going to be qualified by a couple of things. Either the industry that you're in, because there are some certain industry that are going to require mandatory registration. At the same time, you are also going to look at the number of employees that institution has. And the other thing that you're going to be looking at to determine the tier that you're going to fall under is your annual turnover. The other role that the ODPC has is as an educator. They also advise on policy. They also have an obligation of promoting self-regulation. And they also conduct assessments on the level of compliance, and that's where they have the ability of instituting the enforcement notices or the penalty notices. Lastly, they also have the obligation of receiving and investigating any complaints by any person. And complaints can be done through a form that has been provided by the Act, and it can be done by the people that you defined before. So here, the specific notifications and approvals that need to be done by the ODPC. The first notification is in terms of data breaches, and we had mentioned that the data controller has an obligation of reporting within 72 hours of knowledge of the breach. Notification 2 relates to cross-border transfers of data, and I think we've been able to belabor the importance of cross-border transfers as well as the relevant protections that are meant to be applied. The third notification is where a DPIA has been concluded that the rights and freedoms of data subjects are in high risk of being breached or infringed. And the last notification is on purpose limitation, which assumes that the data processor or controller retains a valid business reason. I had begun canvassing on some of the nuances of the data protection impact assessment, and I believe we now have a clear understanding of what that is. But maybe I'm going to mention two things. The first is that when you're performing the data protection impact assessment, there are a few considerations that you need to have, including risk mitigation, the safeguards that you're going to implement, as well as security measures and mechanisms to ensure the protection of personal information. What I mean by this is when you're performing this impact assessment, as an organization, you also need to provide the specific measures on risk mitigation, the safeguards that you've been able to put in place, as well as the security measures and mechanisms that you've established. And it would be good practice for you to have all this information curated in a way that in the event that there is an audit that might occur either by an auditor or by the ODPC, then you have all this information in one place. And by this, I mean the DPIA, the policies, the consent forms, all these things need to be collated in one location. So when a DPIA is undertaken, so we've said it's when there's a likelihood of their rights being infringed, when there's automatic decision making, where there's consistent and systematic monitoring, where there's processing of sensitive information, where large volumes of data are being processed, or where there's a combination of data sets, and lastly, where it involves the processing of data from vulnerable groups such as children, invalids, or people with mental challenges. And so we will now go through some of the previous enforcement notices and penalty notices by the ODPC so that you can be able to appreciate the ramifications of non-compliance. We find that Roma School, that is a primary school, was fined 4.55 million, which equates to around 31,000 USD. And here we see that the nature of the complaint was posting a minor's photo without the parents' consent. Oppo Kenya is a tech company that was fined 5 million, or the equivalent of around $35,000 on account of posting a data subject's image without consent. We also see a digital credit provider, WhitePath Limited, that was fined 5 million on account of illegally accessing the loanee's contacts and sending unsolicited messages to the said contacts. And by this, I mean these incidences that we're all hearing of these credit companies calling everyone on your phone book to settle a debt. At the same time, we also saw Casavera, where they were fined 1.85 million for posting an image of a reveler without their consent. And we also see a property manager, Regus Kenya, that was fined 5 million for frequently spamming automated or improper information. And so one of the other things that I'd also want all of you to put in mind, especially in relation to your going to market strategies, is that it's going to be fairly important for you to ensure that consent is a key ingredient throughout your product cycle, where you're thinking about consent all through. And so if you're thinking about sending messages to your customers, have they given consent? If you're sending emails to them, have they given consent? If you're collecting information, have they given consent? And so as you're looking at all these operational aspects that are the bread and butter of what you do on a daily, I'd want you to put the lens of consent as you are approaching all these issues. So lastly, I'm going to be talking about compliance strategies. I'm going to talk about a few and cede the floor to Gentrix to also canvas the rest. And so as Lotus, we can be able to offer the services of data protection training, where we come to institution and essentially offer data protection training, which would be more detailed. And so this training is going to cover both general training, where information that general employees would require is going to be given. At the same time, we also offer specialized training for certain departments where we believe some more training would be required. For example, in departments that deal with large volumes of data, in departments that deal with automated decision-making, things like that. At the same time, we also review material contracts and agreements of our customers, and we also provide data protection impact assessment services, or you can be able to do this on your behalf. Lastly, we also do vendor assessments, where we look at, we perform an audit to determine your level of risk and some of the things that you might require to do with your third parties to ensure compliance with the Act. Gentrix, if you may.
Thank you, Kaga. I think that was really, really clear. Yeah, so as far as compliance strategies go, I think the main thing that I want to stress, other than consent, is what I said when we were dealing with the jurisdiction. And I think it can apply to anything. Always remember, when you're dealing with this platform, when you're dealing with this feature, improvement, whatever it is, what is the feature, number one, what is it doing? What exactly is the feature and what is it doing? Whose data is it dealing with and who has access to it? And so when I think when you have this at the back of your mind at all times, then you start having what I like to call data protection hygiene, in that at all levels, at any point of the product life cycle, the user's data or the data subject's data is really respected and protected. So some of the other compliance strategies, and I think, Kika, you've covered some of the main ones, but I think maybe we can also look at consent management. Remember, we said that one of the main considerations that you need to have at the back of your mind at all times is consent, but sometimes you find that maybe your policies, your agreements, or the way that you collect consent is not properly done. Remember the considerations that we spoke about when mentioning consent. It has to be informed, it has to be unequivocal, it has to be free. Are you sure, or are you certain that you're collecting consent in the best way possible? We've also spoken about having a record of processing operations. I think Kaga, you already mentioned having collating some of these processes, some of these documentation, and just making sure that you have the best, again, hygiene when it comes to data protection. Earlier today, I was telling Kaga that I think that the product manager is a really good candidate for a data protection officer, because in your team, you're most likely the only person who sees this product from the inception to the end. You see all its iterations, you design some of them. You're probably in charge of things like the assets. Are your assets respecting image rights of the people, even in those assets? So there's a lot of strategies that you can undertake, but there are also a lot of considerations that you need to have at the back of your mind. I would encourage you to reach out for assistance where needed, and also just keep updating yourself of some of the developments. I know that I know that someone at the beginning said that the trends, when you talk about the upcoming trends, one prediction that I have is that we're going to have more and more enforcements by the ODPC, and eventually some of the cavalier way in which we have been treating data will really change, and will become a society that eventually respects data, if not for the fact that it's a right, then it will be because we're being fined through our noses. So just to encourage you that it's possible to be informed, and it's you could be the person that protects the organization from some of the enforcement repercussions. So thank you so much for your time. Our contacts are on the screen. Please feel free to reach out for any questions, trainings, whatever you need, we are at your disposal. Thank you so much.
Maybe any other question? Perfect. So maybe one last parting shot. We have found in our experience that beginning compliance is better, especially when you're faced with an enforcement notice or a penalty notice. They believe that it's important for you to begin compliance, and I'd really advise some of you to begin, or rather all of you, to begin making some of these preliminary steps, such as registration, such as having some of these policies in place. Please put this into consideration on account of some of the penalties that you've also seen that can be put in place if you're not careful. So data protection hygiene. I'll cede the floor to the organizers. Hello, anyone from product managers? Hello. Okay.
Yeah, hello.
Have a lovely. Oh, perfect.
Yeah. So since I see Theia is not present, I want to thank you and also Gentrix for your presentation and your coordination to ensure you both shared the content, presented well, and also answered each and every question that was addressed. Then one of the attendees asked whether you would share the slides. I'm sure you will share to us, then you can share to them. And lastly, since we were covering about data protection, I'm sure Theia was recording on his end. So in case a person has issues with that, they should reach us to on the same. So with that, thank you
Correct.
for everyone's
That's
attendance.
exactly what you're talking about. Yes. Consent.
Yeah, so with that from my end, it's thank you to you, Kiega, and Gentrix, and also the attendees. Have a lovely night.
Thank you and have a lovely night as well.
Thank you, everyone.
Yeah, oh, my name is Roy Mange Kinoti. Yeah, I never introduced myself.
Nice to meet you, Roy. Asante sana.
Nice to meet you too.